Bienvenue tout le monde. Welcome. On behalf of Vrinda Narain and myself, thank you for being here on Zoom with us this morning. It's been a hard, long year of hybrid, online, in-person educational experience, and so we appreciate your presence on a Friday morning on Zoom. I wanted to begin with a land acknowledgement, which I think is particularly important in the context of an event marking an important historical moment in our constitutional history. So McGill University and Montreal, since many of us are not on campus, is located on land which has long served as a site of meeting and exchange amongst Indigenous peoples, including the Haudenosaunee and the Anishinaabe nations. I wish to acknowledge these nations as the traditional stewards of the lands and the waters on which we meet today. I think it's particularly critical on this 40th anniversary of the constitutionalization of Charter and Indigenous rights to reflect on how our understanding and engagement with rights discourse, with constitutional remedies may be developed so as to contribute to reconciliation between Indigenous and non-Indigenous peoples in Canada. Vrinda and I also wish to begin today by thanking the Center for Human Rights and Legal Pluralism, including co-director Nandini Ramanujan, for encouraging us to do something to mark this anniversary, and most specifically to Sharon Webb, who's been so helpful and instrumental in organizing this event. In planning the event for today, we wanted to create actually somewhat of an informal space or roundtable for an exchange of ideas and insights about the significance of the Charter and of the constitutional entrenchment of Indigenous rights. And we thought it would be interesting to focus on exchanging between many of our center members and other McGill colleagues and colleagues in the Montreal area, as well as visiting scholars, to share with each other some of the work we've been doing and the ideas we've been having, because we sometimes are off at conferences around the world or on Zoom around the world and don't take the time to share the work we're doing with each other. So we thought that might be a nice format and focus for today's events. So our panel, our roundtable today is organized into two panels, and we'll have a break between the two if you need to only participate in one or the other. The first one examines missing rights, we entitled it, and the second, interpretive complexities. We entitled this workshop more generally the 40th anniversary of the Charter, Unfinished Business, in the hope of exploring not only where we've come from and what has been accomplished over the past 40 years, but also to reflect on continuing gaps and difficulties that continue to confront our country and our societies regarding the constitutional protection of rights. To explore some of these contradictions and complexities, and to remind ourselves of the importance of being vigilant to safeguard the gains that we've obtained through the protection of rights, and also to recognize the risk of the erosion of certain protections as political and legal dynamics evolve and change. So with that, I wanted to turn things over to my colleague, Nandini Ramanujan, who will be chairing the first panel.
So bonjour, good morning. Welcome everyone. It's such a great pleasure to have you this morning with us. It is a real privilege for me to be part of this important conversation on the missing rights as we mark the 40th anniversary of Canadian Charter of Rights and Freedoms. My name is Nandini Ramanujan, for those of you who do not know me. I have been with the Center for a very long time now, and currently I co-direct the Center with Professor Frédéric Maigret. And we have two previous directors of the Center with us, Professor Sheppard and Professor Crépeau, and Professor Narain and Professor Jodoin and Professor Trilsch. They are all members of our Center. So it really is a conversation among colleagues and friends. I will be moderating today's session, which, as Professor Sheppard says, is called Missing Rights. And it focuses on three frontline concerns of our time: economic justice, environmental justice, and justice for migrants who, without voice and representation in the political process, are denied of fundamental freedoms. This panel features three distinguished experts and dear colleagues and friends. And the first presentation will be by Professor Mirja Trilsch, who is a professor at Département des Sciences Juridiques at Université de Québec à Montréal, where she teaches constitutional law and international human rights law. And she will speak to the dichotomy between civil and political rights and socioeconomic rights, which prevails in Canadian constitutional law. Persistence of this dichotomy is particularly problematic as there is a clear consensus at the international level on the interdependency and indivisibility of rights. So I will hand over the floor to Professor Mirja Trilsch for the next 15 minutes, and then I'll introduce our next speaker. So over to you, Mirja.
Thank you very much, Nandini. Thank you for the introduction, and thank you for the invitation. Vrinda and Colleen, thank you for putting this conference together. So started my timer, and yeah, so the title of my presentation is The Charter at 40, Who's Still Afraid of Social Rights. I'm suggesting that, you know, there's some sort of fear or at least skepticism towards social rights in Canadian constitutionalism. And I would like to quickly explain that premise by taking you back to one of the early charter cases of the Supreme Court, Irwin Toy in 1989, case known for, you know, its interpretation of freedom of expression, but which also dealt with Section 7, the right to life, liberty, and security of the person, and the question whether the right to security of the person could be understood to protect economic liberty. It was ruled that it does not, but here is where things become interesting. In an overture by Justice Dixon, he said, and I cite, "The rubric of economic rights embraces a broad spectrum of interests, ranging from such rights included in various international covenants as rights to social security, equal pay for equal work, adequate food, clothing, and shelter, to traditional property contract rights. To exclude all of these at this early moment in the history of charter interpretation seems to us to be precipitous." So in 1989, Canadians were told that it was too early to decide whether economic and social rights could be protected. Well, it's been 33 years since Justice Dixon wrote this, and the charter still does not protect the right to health, to social security, and to housing or to work. So in the remaining, 13 minutes, I would like to briefly explore three things. First, to look at, you know, has there been any progress at all? Secondly, is it a problem that that economic and social rights are not protected under the charter? And third, to look at, you know, what are the stumbling blocks that we cannot seem to be able to overcome? So first things first, has there been any progress? Courts in Canada have indeed found charter violations in cases dealing with issues that are traditionally related to economic and social rights, such as healthcare. We think of Eldridge and the Eldridge and Chowley cases before the Supreme Court, or Canadian Doctors for Refugees before the Federal Court. Several cases on social security, Hislop, recently Fraser, to name but these two. There are many other examples. There is some case law also in respect to housing in a lesser known case before the Supreme Court of British Columbia, Victoria versus Adams. The thing is, if you look closer at some of these cases, you realize that many of them can hardly be seen as advancing social justice. So Chowley was, Chowley basically secured the right to avoid waiting times in the public health system for those fortunate enough to be able to pay for private health insurance. And Victoria versus Adams, in fact, restored the right to sleep in a tent in a public park for homeless people. So, you know, those are nowhere near what the right to health and the right to housing are about at their core. The best bet for social rights under the Charter thus far has without a doubt been the right to equality, Section 15. But non-discrimination is obviously a, only very partial protection of these rights under the Charter. All in all, we're unfortunately mostly still stuck in 1989 because economic and social rights in their proper sense and form have not found their way into the Charter. So let me get to my second question. Is that a problem? Well, first and foremost, it makes it difficult to argue under the circumstances that Canada respects all of its obligations under international human rights law, especially, of course, under the International Covenant on Economic, Social, and Cultural Rights, which explains why the United Nations Committee for Economic, Social, and Cultural Rights regularly begins its observations about Canada by pointing out its concern over the fact that, and I cite, economic, social, and cultural rights remain generally non-justiciable in domestic courts. In 2016, the committee added that it was also concerned at the limited availability of legal remedies for victims in the event of a violation of covenant rights, which may disproportionately impact disadvantaged and marginalized groups and individuals, including homeless persons, Indigenous peoples, and persons with disabilities. So in other words, the dichotomy between civil and political rights on the one hand and economic and social rights on the other leads to, or it, at the very least, exacerbates social injustice because it makes it almost impossible to tackle some of the most pressing human rights issues for some of the most vulnerable populations on the basis of the Canadian Charter. For example, the right to clean water for Indigenous communities, the right to safe and affordable housing for persons living with disabilities, or the right to have access to quality healthcare in a timely manner for basically just about anybody relying on the public system. That list could obviously go on and on. And that takes me to my third question. Why are we stuck in 1989? I think it's noteworthy that in other jurisdictions, constitutions that are lacking express provisions on economic and social rights have progressively evolved to embrace these rights over time. The constitutions of India and Germany are some examples. However, what these constitutions do have, contrary to the Canadian Constitution, are express general provisions that can be mobilized in order to interpret the provisions, for example, on the right to life, to physical integrity, to dignity, or to security, so as to include constitutional protection to nutrition, clothing, shelter, healthcare, or a decent standard of living. But even in the absence of such general clauses, the rights I just mentioned can become the object of an interpretation that is sufficiently large to include certain aspects normally protected under social and economic rights. And I think the Inter-American Court of Human Rights, the European Court of Human Rights, as well as the Human Rights Committee have all done so in the past. For Canadian courts, especially, of course, the Supreme Court, the major obstacle in this respect for some time seemed to be the distinction between negative and positive rights, and the now debunked claim that the Charter only guarantees negative rights. So this whole positive-negative divide was basically synonymous to the divide between the two categories of rights. Civil and political rights were framed as negative rights, and therefore had their place in the Charter, while social and economic rights were framed as positive rights and therefore did not have their place in the Charter. So this logic, as Nandini already mentioned, was completely discredited under international human rights law. And it was also rejected by domestic courts in other jurisdictions. And it actually proved itself wrong over time as the Supreme Court of Canada recognized more and more positive obligations under the Charter, especially under Section 15, the right to equality, but also at least under certain circumstances in relation to other rights, such as freedom of expression in Bayer, and even the right to security under Section 7, for example, in New Brunswick versus G, pertaining to access to legal aid. And let's not forget the constitutional right to access to justice created under Section 96 of the Constitution Act of 1867, even if that's not a charter right, but that right was created in Trial Lawyers Association of British Columbia. More recently, in the 2021 Toronto City Council case, the dissenting judges went so far as to say that the distinction between positive and negative rights is an unhelpful lens for adjudicating charter claims. But they also claim that the Supreme Court has always recognized that rights and freedoms have both positive and negative dimensions, which to me seems wildly exaggerated, though. Anyway, the fact of the matter is that while positive dimensions of rights became progressively recognized, that did not inversely result in the coming of age of economic and social rights under the Charter. Instead, a new distinction was drawn, and that distinction was set out in the Autant case in 2004, where the Supreme Court said that the Charter does not grant a right to the creation of a particular benefit or a specific legislative scheme. The Charter will apply once government has put benefits in place and once legislation was adopted. And in that case, it has to distribute those benefits and legislate in a non-discriminatory manner. So that brings us back to what I said earlier, namely that the Charter essentially protects economic and social rights only in their non-discrimination dimension. It does not protect economic and social rights as freestanding rights, as some judges will sometimes put it. So, for example, the right to housing can only exist insofar as governmental programs exist that provide for housing or set standards for housing. The truth is that is not much of a right at all, not in the sense of charter rights. I think it's time to stop pretending that statutory benefits can provide for an adequate protection of economic and social rights. And unfortunately, under its current limitations, the Charter is really not of much use in the fight against homelessness, poverty, the economic and social marginalization of Indigenous peoples, and many other pressing human rights issues. Although it is in relation to these issues that Canada direly needs a human rights-based approach, but unfortunately the Charter currently does not have much to offer in that respect. That does not mean that we should not keep pushing and arguing for the inclusion of economic and social rights. I said earlier that the Canadian Constitution does not contain a general sort of social state clause. That does not mean that social justice is a concept that is incompatible with the Constitution. On the contrary, I think there are good arguments to be made that the Constitution in general and the Charter in particular actually embrace social justice. First and foremost, the basic intention behind the adoption of the Charter was to bring Canada up to speed in terms of the importance and the value accorded to human rights globally. And given that, all rights are interrelated and are interdependent, that means is that as soon as you constitutionalize a good number of rights, you are by definition implicitly recognize or giving some sort of entrance to other rights. So we saw this in cases like Shaoli. You cannot dissociate the right to life and the right to security from the right to health. Secondly, there is at least some textual support for social justice considerations. If you look at Section 36 of the Constitution Act 1982, which is not part of the Charter, but which speaks to the federal and provincial government's commitment to promoting equal opportunities for the well-being of Canadians and to providing essential public services of reasonable quality. And thirdly, the interpretation of the Charter provisions has, of course, shown support for social justice in the past. So in Oakes, the Supreme Court affirms that a free and democratic society is committed to social justice and equality. And the very concept of substantive equality, of course, could not exist without social justice considerations. So to conclude, I believe there is room for growth in our living tree constitution. I think that the Charter could embrace social and economic rights. I just think that under a currently very divided Supreme Court, it is hard to imagine that this could be happening anytime soon. So thank you very much, everybody.
Thank you very much, Mirja. And I'm sure there'll be plenty of time for conversation on what you have just, issues you have just spoken to. So I will move along and invite Sébastien Jodoin, who will talk about environmental justice and how and to what extent existing rights in the Charter have been and can be interpreted to safeguard individuals and communities from environmental harm and discrimination. He is a professor at the Faculty of Law. He's a member of Center for Human Rights and Legal Pluralism. He holds the Canada Research Chair in Human Rights, Health, and the Environment. And he's very well placed to speak to the issue of environmental justice in the context of Canada. So over to you, Sébastien.
Thank you so much, Nandini, and it's great to be here. And I think I'm going to be building a little bit on the presentation we just heard. So I'm just going to share my screen here. So I want to begin basically by giving you a brief discussion of whether or not, in fact, the right to healthy environment was considered for inclusion when the Charter was drafted. There actually were some proposals that were made in testimony before different committees. And I'll just note one because I thought it was interesting when I discovered it, because it's from a McGill professor at the time. So Noel Lyon, who's I guess was a professor in the faculty in 1970, wrote in his testimony before the committee, wrote, "I am disturbed by the obsessive interests of those constitutional lawyers who dominate current public discussion with traditional legal and political rights and their apparent unawareness of the need for protection of what I will call the fundamental environmental rights of man." So there actually were proposals by experts, by the Canadian Environmental Law Association at the time, to include the right to a healthy environment in the Charter. Eventually, all of those proposals were dropped and not retained, and pretty much because based on the evidence of the people who've been interviewed about this, they said it was just not on the agenda. It was not something that the architects of the Charter were really willing to entertain. Now, it's important to note that indeed in 1982, the number of constitutions that included the right to a healthy environment were pretty minimal. We had 8. Now, in 2022, how many? Oh, I see it's already gone for it. All right, so we have 84 that now include this right in 2022. And beyond that, we also have 52 countries where the right to a healthy environment is included in legislation or has been recognized by courts as being part of the constitutional framework under different rights. So if we look here now at a map of the world, in dark green are the countries that recognize the right to a healthy environment in their constitutions, in their legislation, also in international regional agreements. And here we're talking about also implicit and explicit recognitions in the Constitution. And this is data from 2012, but actually hasn't really changed since then. You can see that Canada is one of the few countries now that doesn't in any way recognize the right to a healthy environment in its constitutional legislation or international agreement. And you'll also notice that the other countries that are with us in this refusal are the United States, Australia, so countries with Anglo-American, perhaps resistance to socioeconomic rights in some ways, although you should know that in South Africa and India, there's quite strong jurisprudence around the right to a healthy environment. And then other countries that are maybe not well known for their human rights record. Within Canada, actually, in 1978, the right to a healthy environment is recognized dans la loi québécoise pour l'environnement. It's also included in the Environmental Rights Act in the Northwest Territories in 1988, in 1991 in the Yukon, in 1993 in Ontario, and in Nunavut in 1999. And most recently, in 2006, Quebec actually added this right to the Quebec Charter of Rights and Freedoms, though it's in a part of the charter that does not make it possible for you to invalidate legislation on the basis of this right. So it's been added along the other economic, social, and cultural rights in the Quebec Charter. And then one other thing I need to mention is that currently in Bill S-22, the Canadian government has a bill in which they're proposing to add the right to a healthy environment in the Canadian Environmental Protection Act. And under that act, as a result, the minister would have to prepare an implementation framework for how this right should shape policy making and decision making under this act. So we're not actually at the level of creating a new recourse, and we're not at the level of constitutional enshrinement, but we are at the level of basically integrated within Canadian environmental policy. And I should disclose that I'm actually working as an expert with Environment Canada to help them develop this implementation framework. So we do not have a right to a healthy environment in our constitution. Why does this matter? I want to take you to a part of Southern Ontario known as the Chemical Valley. It's a region that accounts for 40% of all of the emissions produced by the petrochemical industry in Canada. There are 57 facilities on the US and Canadian side that emit approximately 10% of all emissions in Ontario. And they're within 25 kilometers of the, I'm going to say this incorrectly, Amjiwanak Nation. I apologize, First Nation. So I'm going to show you here a map of this area. You can see where the, so the city of Sarnia is, and you can see where the First Nation reserve is. And in red, what you have there are levels of pollutants that are way above what is in fact safe and required in Ontario. And in orange also above. And you can see that in fact this First Nation is right in this area where ambient air levels are way above what they should be for safety and health. So there actually are more emissions in this one region than the entire province of Manitoba. There's also leaks of toxic chemicals in the groundwater. And basically what's enabled this to happen is traditionally, and for a long time, was the lack of a cumulative effects policy. So each facility could be approved on its own terms. And there was never an effort by the Ontario environmental regulators to say, okay, well, now we have 25 of these. What is the cumulative impact of that? No, they always looked at each individual facility. And you also had very ineffective enforcement of environmental rules, which were also quite lax in any case. And the problem is that these facilities are, as I mentioned, right where people live, right where children go to school, right where they play outside, right in the water that people may, and the lands that people may enjoy in different ways. And the result of that is high rates of cancer, high rates of asthma, all sorts of other respiratory illnesses and hospitalizations. So in 2009, this couple here, Ada Lockridge and Ron Plain, submitted with the help of EcoJustice a request to the Ontario government to basically review how it was regulating emissions in this community. And the Ontario government did nothing. So in 2012, they initiated a charter challenge against the Ontario government's allowing a permit that in which they allowed Suncor to increase its production at its Sarnia refinery. And they argued that this violated Section 7 and 15 charter rights. So, of course, a lawsuit was opposed by the Ontario government, was also opposed by Suncor. In the end, the lawsuit was actually discontinued because Ontario announced they were finally going to have a cumulative effects policy. So in that basis, and given other challenges that had been faced in this litigation, the EcoJustice and the plaintiffs decided to abandon their claim. Now, despite some improvements, the First Nation community and the citizens of Sarnia actually continue to be exposed to dangerously high levels of chemicals. So basically what we need, what this illustrates is the need for the constitutional protection of a right to a healthy environment, one that can be accessed by communities and individuals to protect their environment, and also against violations of even environmental law and standards that really threaten their lives and their safety. So there actually have been 14 cases, known cases, that have used Section 7 and Section 15 to challenge different forms of environmental harm. So some against cruel cruise missile testing, inadequate liability for nuclear reactors, adverse health impacts from proposed landfill and waste incinerators, fluoridation of public water supplies. That one I would like to put in brackets because I actually don't think there's anything wrong with fluoridation of public water supplies. Approval of pesticide use, pollution from proposed oil and gas wells, increased production at a petrochemical facility, as I've mentioned, and more recently, a number of cases filed by youth invoking Section 7 and Section 15 of the Charter as against the inaction of either the federal government in the field of climate change, or in relation to the Ontario government's rollback of climate protections and policies. Now, all of these cases have actually been unsuccessful. Now, one, as I mentioned, was abandoned. The others were all rejected at different stages. But no court has yet to close the door in principle to a Section 7 or 15 environmental plan. And if we look at Chiuli, and we can definitely see that there's ground there for building a claim that addresses risk to health caused by government laws. And in light of the decision in Fraser, there's definitely a lot of ground also to build a Section 15 claim addressing adverse effects, discrimination related to environmental harm. But for so far, this is all speculative. And all of the cases that have gone to court have been rejected due most often to a lack of justiciability, a lack of standing, or a lack of evidence. And justiciability, I think, has been the biggest hurdle in many of these cases. The most promising case that we have in this area is Mather v. Ontario, which is a challenge against the Ford government's decision to roll back measures that were put in place to reduce carbon emissions. And that was challenged by the Ontario government at first instance, and that the challenge was dismissed with an Ontario Superior Court judge finding that in fact you could have a Section 7, Section 15 claim go ahead, that it was prima facie justiciable. And so we will see how that case proceeds. So all of this, though, I think built the case for thinking about what a right to a healthy environment could contribute to this discussion. So I'll just briefly discuss the advantages of what a right to a healthy environment could offer, and then some of the challenges. So, and I should say that this builds on experiences of the many other countries, the 100+ countries, 150 other countries that have either implicitly or explicitly recognized the right to a healthy environment in their constitutional frameworks. So we can see that in those jurisdictions, this right offers enhanced access to justice for environmental harm and discrimination. You don't need to go through, you wouldn't need to go through the right to life or personal security to make your claim. You could go directly in terms of making a claim due to your entitlement to a right to a healthy environment. We can see that it's easier to challenge environmentally harmful state action. There's less of these provisions normally will make it possible to invalidate legislation and invalidate unlawful, unconstitutional state action. We can see also that there are stronger environmental laws and policies, sometimes that are actually required by courts, but also within the normal machinery of government when they are going through the usual ensuring that their laws comply with the charter. You could imagine that could also lead to a greater impetus for stronger environmental laws and policies. And finally, and perhaps most importantly, there's a presumption of non-regression when you recognize the right to a healthy environment in the Constitution. So, and this is very clearly the experience, for instance, in France. So this would prevent environmental rollback. So the decision, if you look at Ontario, going from the Liberals to the Ford government, where they decided to roll back these climate policies, this would be the sort of thing that could very easily be prevented in the context of a strong recognition of a right to a healthy environment. However, and I want to conclude here, it's not the case that just because you add a right to a healthy environment in the Constitution that this will magically lead to pristine water and air for everyone overnight. There's a number of things that are required. You need resources for public interest litigation. You need lawyers, you need scientists, you need resources to pay for the legal fees, and especially in those communities most affected by environmental harm. You need, of course, courts willing to receive those claims and not throw them out over justiciability or lack of evidence. You also actually need the scientific research to be available in the first place. So there's a lot of risks that are tied to environmental harm, risks to health, where there's very little research or limited research, and that makes it quite difficult to build a case. And I think most importantly, I don't know if this is an outcome of what a right to a healthy environment would bring, or is actually required for the right to a healthy environment to have this transformative potential, but we need a transformation, a pretty significant transformation in the political economy of Canadian policymaking in terms of natural resources and the environment. Now, if we could do all of these four things, we might actually not even need a right to a healthy environment. We might be able to proceed through the existing rights protected in the Charter. And I do have some optimism from different events across Canada and the mobilization of an entire generation that perhaps we are laying the groundwork finally to start to tackle some of the underlying reasons why environmental harm occurs across Canada. So, thank you.
Thank you very much, Sébastien, for that illuminating and insightful presentation. And there's a lot to think about and talk about. But before that, I will invite our dear colleague, Professor François Crépeau, who will shed light on the barriers to justice for migrants and will explore the feasibility of the development of planning in migration policies, a process which he claims should involve all stakeholders, in particular migrants themselves. Professor Crépeau holds the Hans and Tamer Oppenheimer Chair in Public International Law at the Faculty of Law. He was the former director of the Center for Human Rights and Legal Pluralism. He was the former Special Rapporteur, UN Special Rapporteur for the Rights of Migrants. And he has he holds many positions as an international expert on the rights of migrants, but most of all, he is a passionate advocate for the rights of migrants. So over to you, François, for the next 15 or 17 minutes.
Thank you very much. I'll share my screen as well. Okay, good. Thank you very much, Nandini. I will pick up from what Sébastien just said. If we can have a transformation of the political economy of policy making, we might have a great improvement of the conditions for migrant workers in Canada and elsewhere. And I'll conclude with that. So you'll see that there are converging analysis. First of all, migrants in Canada are in principle covered by the Charter, by the interpretation of everyone in the Singh decision, but they face a colossal implementation gap. Because they are the vast majority of them here in Canada and elsewhere in the world, the vast majority of them are low-wage migrants with little social capital. They live very often in precarity and abuse. We're thinking here of essentially undocumented migrants and temporary migrant workers who are in temporary migrant worker programs. They lack any political power. They have no voice in the policy debates, in the public discourse. And again, this is not simply a Canadian problem. It's all over the world, and it's structural in our economic systems. So let's first unpack a little bit why migrants are in such, these migrants. I'm not talking about the expats, the Canadian engineer in Doha. No, not these people. They have social capital. They have employers who might defend them. I'm talking about all the other migrants. So first of all, the precarity in which those migrants live is a social, political, and legal construct. Migrants come because there is a labor market for them. A labor market that might be the regular labor market, that might be a temporary labor market, or might be an undocumented, an underground labor market. Migrants go to places where there are jobs for them. Migrants are smart. They don't go to places where there's no job. They want to create a future for themselves and their family, and they look for jobs. And because of that, we have in the past 40 years organized the competitiveness of several industries based on the use of cheap labor. We have, in order to lower labor costs, we have delocalized most of manufacturing. But there are economic sectors that cannot be delocalized: agriculture, care, construction. We can't delocalize that. And therefore, what we've done is to delocalize the labor conditions from countries in the south to the north. And this is very well known. This has been documented by sociologists, political scientists, lawyers, and there's very little oversight over this. This precarity results from the combination of two sets of policies. Migration policies, which create the fear of being returned home empty-handed, which is the end of the migration project, in which the migrants, their families, their village have invested so much, often at huge cost for them, and labor policies, where labor standards are simply not applied and oversight doesn't work. And therefore, the employers hold great power over the lives of the migrants, and they fear being returned if they do anything to, for example, anger the employer. And this happens on a regular basis everywhere. Therefore, this precarity is completely policy-induced. It's policy-induced in order to reduce labor costs. We know that millions of employers need low-wage migrants, and yet we block low-wage migration. Premier Legault said last fall that he didn't want immigrants earning less than $53,000 in order to not reduce the mean wage in Quebec. Well, he knows very well that most of the orderlies in the healthcare sector do not earn that, those who work for agencies, for example. And yet he doesn't want them. He says he doesn't want them, but in fact we need them, and the employers get them, but they get them in a situation where precarity silences those migrants, either because they're undocumented or because they are in temporary programs and risk being returned if they voice any concern. And therefore, this prohibition of migration, of low-wage migration that we find in most countries in Europe, in North America, but also in host countries in the South, in South Africa and Malaysia, this prohibition creates and subsidizes all the underground markets that exploit migrants. And that is one of the big issues. Temporary labor migration programs do the same thing with a legal status. We have created a system where the legal status creates precarity, which silences migrants. For example, the single employer temporary status means that the employee is at the mercy of the employer and will not protest exploitative practices for fear of being fired and losing the residence permit and work permit and being sent back home empty-handed. Standards are not applied. For example, in Quebec, health and safety regulations do not apply to domestic workers. Inspections are absent. Travail Québec doesn't do the kind of labor inspection that would protect all workers. Quite often, in labor inspections will work hand in hand with immigration, hunting down undocumented workers. Unionization is discouraged or prohibited. We know that because of the Fraser decision in the Supreme Court, and protesting is punished. This is bolstered by the kind of political discourse that we're having about migrants in general. We can, for those who follow the French presidential election, it's a central theme in the Le Pen, Zemmour, Pécresse right-wing discourse. And the latest polls I've seen in The Economist is that Marine Le Pen versus Macron, Marine Le Pen might make 45% of the vote, which is enormous for an extreme right leader. So we have a system of electoral democracy that does not represent migrants. They do not vote, they're not elected. And therefore we have migration policies and migration discourses, which are made by non-migrants, the politicians, for non-migrants, their electorate. We're in the same situation as when policies about women were made by committees of men. They simply didn't know what they were talking about, and women were not bringing the reality check of their lived lives. And we see that women, 80 years after having gained the right to vote, still need the Me Too movement. So migrants who don't even have the right to vote certainly need a Me Too movement as well. These migration policies are often, not always, based on stereotypes and myths, which go uncontradicted for lack of political will. And we have, in many political constituencies, we have created a permanent crisis mentality, in which certain politicians actually thrive, and especially extreme right. We also use a liquid language to talk about migrants in order to portray a threatening mass where there's no individuality. Like, you know, when in times past, you know, all women were like this. We qualified, you know, women couldn't drive or couldn't be CEOs or whatever. They were all painted with the same brush. And that was true for all minoritized groups. Well, for migrants, it's still the case. Migrants bring illnesses, migrants bring crime, increase in security, etc. We also have introduced criminal law, language standards institutions in an administrative law field, which doesn't have the guarantees of that criminal law has evolved over centuries. And yet today, the only judge who can send people to extrajudicial execution, torture, and arbitrary detention is the immigration judge. And there are no guarantees of evidence and of procedure to protect innocent people from that. It's called crimmigration by specialists. And yet, we're all descendants of migrants. It's in our DNA. It's a normal coping mechanism. And there's no reason to believe, you know, after what Sébastien told us, that migration pressure will abate. I mean, economic imbalances and climate change plus political upheavals mean that migration will certainly continue and probably increase. And therefore, the issue is, what do we do? What do we do? Do we empower migrants so that they can fight back? Or do we continue disempowering them? The cost of what we're doing now is indecent. The human cost for the migrants, the financial and human costs for host societies are colossal. There is an answer. There is a framework that has been adopted in 2018, which was then a big surprise for many of us, because it's the Global Compact on Safe, Orderly, and Regular Migration. It is a document which, although being soft law and therefore non-binding, has been adopted by 150 states of the UN General Assembly. And this negotiation was made possible because politicians were absent from it. It was negotiated by civil servants, diplomats, experts, international organizations, civil society organizations, academics, all people who knew what they were talking about, contrary to politicians, and who brought together expertise and thought through the issues that migrants were facing, and based the document on the good practices, the lessons learned of many countries, countries of origin, countries of transit, countries of destination. Some politicians reacted negatively when it was offered for signature at the end of the process, but the document had been adopted, and that is quite extraordinary in terms of a breakthrough. It provides a conceptual framework for coming decades. We're not talking about implementing it within years, because what it proposes is goes against what most states are doing at present. I think we have to see this as a long-term process, probably just like what the Universal Declaration triggered in 1948. And that process of bringing human rights, developing human rights, has taken 75 years, and we're still doing it. I think the Global Compact could play the same role. Canada is a champion country. There are a few champion countries around the world, and it defined itself, it accepted the title of champion country of the Global Compact. The central recommendation of that Global Compact is to facilitate mobility. The word facilitation is used 62 times, which is not an oversight. And I will go through a number of the 23 objectives of the Global Compact just to show you how this facilitation should go. And you will see that it's not exactly what states are doing now. So there are 3 objectives which show that states will still need repression, the response to migrant smuggling, the fight against human trafficking, and the managing of borders in a secure manner, which means that you have to have security processes in place. So this is something that all states wanted to have, and especially Global North states in the Global Compact, and it's there, and it's not inappropriate. But if we look at all the other objectives, we'll see that most of them aim at reducing repression against migrants and facilitating mobility. So, for example, Objective 5, enhance availability and flexibility of pathways for regular migration, i.e., if you don't want irregular, undocumented migration, offer them mobility options, which means that Mr. Legault, for example, should recognize that people, will come for low-wage jobs. And we'll see that how this needs to be governed inside a constituency like Quebec or Canada or any other country. So this idea of creating pathways for regular migration in order to replace undocumented migration, in order to replace, that states need to offer mobility options and take over the market from the smugglers. That's the idea. Facilitate family reunification. The Global Compact talks about a right to family life, which really does not exist in international human rights law. It exists in European human rights law, but not in international universal human rights law. But they talk about this right to family life, yet the vast majority of the millions of temporary migrant workers do not have the right to bring their family with them. And so that is something that should change, but it will take years before this happens. Guarantee fair, ethical recruitment and decent work. Well, this is quite extraordinary because this is what the vast majority of the labor codes of the world are saying, except that they're not applied to migrant workers. They remain unapplied. And so the guarantee of decent work is a key element, and yet it's not happening, not because the legislation is not there, but because there's no implementation, and we'll have to overcome this implementation gap. Facilitate transition between statuses. For many migrant workers, changing from this temporary migrant worker program to that temporary migrant worker program or to a permanent resident status means months, if not years, of waiting, and very often it means that you're in administrative limbo in between. Facilitate, objective 7, facilitate regularization of status. The word regularization has disappeared from the English version, English negotiated version of the Global Compact, but it has reappeared in the French translation, the official French translation, which is interesting. But the paragraph has remained. For states, it was a bit too touchy to talk about regularization, but the idea is, why do you keep this abscess in your society of millions of people in an undocumented status when you know they've been here very often for years, if not decades? So regularize them, take away the problem, and states are not currently prepared to do that in their vast majority. Include migrants in crisis preparedness. This is essential for refugees. If, as we can see, Europe was prepared for the Ukrainian refugees. They put in place this temporary protection directive, which they had adopted in 2001, and they implemented it, and suddenly there is a mechanism to get prepared, and we could get much better prepared in terms of emergency response to population movements, like we are prepared for the victims of forest fires or floods in our countries. Use immigration detention as a measure of last resort and work towards alternatives to detention. There's almost no alternatives to detention, to immigration detention, that are available because politicians are not interested. It would mean investing money in mechanisms that do not bring any vote to them. Detention brings vote. Detention and expulsion of migrants brings vote. Creating alternatives to detention, which exist in the criminal law system for people who are much, in theory, much more dangerous than migrants, but they don't exist in immigration law, really. Ensure, look at this one, ensure that all migrants, regardless of their migration status, have safe access to basic services. That's education, social services, healthcare, etc. This is what we've done in Quebec in the past 5 years. We've given access to for children, undocumented children or children of undocumented migrants. We've given them access to education, and last fall to healthcare. Not their parents, but at least the children. And so this is the idea of access to basic services for all migrants, regardless of migration status, which is not happening almost anywhere in the world, including through implementing firewalls. Firewalls mean that public services should not communicate information about their clients to immigration enforcement. Now, if you talk to Germany, if you talk to the US, this goes against their policy of intercommunication between databases, and they just don't accept the idea of firewalls for migrants. Fighting undocumented migrants is considered a security issue, and therefore interconnection of databases is essential for their security policy. 153 states including Canada, have said, well, no, that should not be the case. Migrants are actually not dangerous. Empowering migrants in Objective 16. It's the first time I see the word empower with the word migrant, when, as we've seen, the whole strategy of reducing costs is about disempowering them. And then you have other objectives which go in the same direction. There are blind spots in the GCM. It's not a perfect document. Most importantly, it doesn't talk about the responsibility of host states in maintaining and subsidizing exploitative labor markets where migrants are being, badly treated. But let's, we can talk about that in the discussion. What's the way forward? The first thing is that no country can change their migration, substantially change their migration policy by themselves. We need to do this together. Otherwise, there will be imbalances. And this is probably at where it may happen is at regional level, in regional communities which decide to implement progressively some kind of free movement of people between the countries of the community. And we need to do that in particular to avoid crises, just what we see with Ukraine, and the collective response of the EU is the kind of emergency preparedness that we need to do. We need strategic planning. That's what Nandini announced in her presentation. Unfortunately, migration policies change reactively. There's an event. Someone, arrives on a beach and suddenly there's a flurry of changes to the immigration law. Someone dies in a desert and again, we change the immigration policy, etc. It's constantly reactive to what's happening now. And as we've seen, the aim is to ensure that voters are satisfied. We need to do a lot more. We need to do like we do for all other fields of governance, infrastructure, transport, healthcare. We need planning, long-term planning, 20 years, 30 years, 50 years, in order to think through and have a public debate about who we want to be in 20, 30, 50 years from now. And this kind of debate needs to include everyone. Very often, only the Minister of Immigration is allowed to talk about immigration. Well, no, ministers of education, of healthcare, of agriculture have things to say about that. We need to include all stakeholders, and in particular, I'm underlining unions. Unions have been singularly absent from the debates about migration policies. They're coming slowly, but it takes time. And most importantly, we need to hear migrants, and that's not happening in most cases. What we should aim at is fluid border crossings, allowing more migrants to come and look for work. If you arrive as a visitor in Trudeau Airport and you say, I want to see if there's a job for me in Canada, you're put back in the plane back home. You're not allowed to come and look for work from abroad. We should allow them to do that. Just like, we allow people from Montreal to look for work in Toronto, just like someone from Bulgaria can look for work in France or in Spain if necessary. We need this facilitation through borders, liberalization regimes to have an open and regulated movement. This is what free movement zones are all about. The EU, ECOWAS, SADC, the southern cone of Latin America. The objective is to make mobility easier, safer, cheaper, and faster for everyone concerned. A key condition for that is to reduce migrants' precarity, regularize undocumented migrants, apply labor law, facilitate unionization, implement labor inspections, invest in integration, access to nationality and permanent residence. All this will allow migrants to speak up and to take their own place in our society. For that, we need to replace the zero tolerance policy attitude by a harm reduction policy attitude, as we've done for alcohol and drugs. We need to do that for migration as well. This would reduce the pressure on refugee determination systems. Most refugees would ask for a work permit. It would reduce the power of criminal networks. It would facilitate, border control, because people would go to the border guard. And this was the case in the 50s, 60s, and 70s. It's not science fiction. I'm not saying that we should go back to those years, but we should adapt our systems in order to recover this freedom of movement that we had. And so I think the Global Compact is the first step in probably a long-term conversation that we will have between actors, stakeholders, in creating a culture of human security for migrants and host societies, just like the Universal Declaration created a culture of human rights over almost 8 decades now. Thank you very much.
Thank you, François. Thank you very much. So I see that there are over 50 participants, and we are really happy to have you with us. And I open the floor for question and answers. Professor Richard Yanda is going to break the ice. Richard, over to you.
Thank you. Just to break the ice precisely, thank you to all of the speakers for really challenging and fascinating presentations. I'll aim at a question that I hope cuts across all of the presentations and seek observations from all of the distinguished panelists. I think 40 years on, one of the observations we must all make is that there's a gap, as many of the speakers have mentioned, between our expectations of the sort of social transformation that would have taken place in relation to human rights and what we face by way of actual social discourse and political response. And it seemed almost to be kind of uniform in the presentations that what was needed to advance the agenda was a shift in social discourse. So, for example, on migration, we know that if anything, social discourse is becoming retrograde rather than progressive. That we know that there is resistance to enhancing environmental protection, and we know that social and economic rights are not necessarily being advanced further. So I just wondered if all of the speakers could comment on what may at times seem to be sort of almost purely aspirational discourse in the human rights domain, and this gap between where we think we might have advanced the state of discussions and where we actually are.
I guess this was a question for all of us, so maybe I can start with some ideas. What explains the gap? I think in terms of economic and social rights, I mentioned that in my presentation. It's if framing social issues in terms of economic and social rights takes a human rights-based approach. So if you consider economic and social rights as purely aspirational goals, then that is the opposite of a human rights-based approach. So you need to, I guess it's a conceptual sort of challenge to actually, accept that economic and social rights are real rights. And I mean, this has been ever since the adoption of the International Covenant on Economic, Social, and Cultural Rights. This is something that has been a challenge in international human rights law. I think we have managed to overcome that, but then there seems to be a gap between accepting that in international law, where there's not a whole lot of legal remedies, and then implementing that into the domestic domain, where you have courts and procedures and judgments and binding judgments. So and I guess that's a little bit what I was aiming at by saying who's still afraid of social rights. I think there is that fear to say, oh my God, what is going to happen if we actually accept economic and social rights? But if we really wanted to know what happens, you know, there's other jurisdictions that we can look to and realize, you know, it can work. It needs adjustments in the methodology of rights, but you know, it shouldn't be the tail wagging the dog where we say, oh, the methodology doesn't quite work for rights. So sorry, we can't accept those rights. It shouldn't be that way. It should be the other way around, accept that they're rights and then adjust the methodology. So I'll let my colleagues take over from there.
Well, maybe I'll just say in terms of changing discourses, I would say that actually, I think we've seen in 40 years real significant change in terms of support for environmental protection and recognizing links between health and the environment. And actually, there's polling data, recent polling data suggests that 9 out of 10 Canadians support adding the right to a healthy environment in the Canadian Constitution. There's a few years ago more data that said that I think about 30% thought it was already there. So I think that there's been sort of campaigns led in terms of getting municipalities to sign on to recognizing this right. So I think that I'm not sure if that's where you were going, but I think that the social discourse is actually quite supportive of this. I think that the barriers to actually having it recognized are really actually just tied to the fact that changing the Canadian Constitution is a huge Pandora's box. Even in when there were negotiations on the Mulroney years with me, Charlottetown, there were some people who brought up the idea, oh, whoa, if we're doing this, we should add rights, and then to the healthy environment, other things were brought up. So it just becomes a huge house of cards, not to cite a disgraced Netflix show, but basically it becomes quite complicated. But so I don't think the obstacles are around public opinion or discourse. And I also do, however, think that when you have a lot of these polls, when you ask people like, do you support the right to the environment? Do you support protecting the environment? People are always like, yes, of course. When you start asking people about costs that they might incur as a result of strong environmental measures, then the polling data is a little bit less supportive. And then I think that is sort of where the discourse is at, is we all want a healthy environment, but not everyone is willing to assume the burden of what that would mean for them personally. And I think that's where we still have a lot of work to do.
Thank you, Mirja. Thank you, Sébastien. I have a question on chat, and that is directly for François. And then I have 2 others in the queue. So the question on the chat, I read, I am a Bebe from Ethiopia. Thank you for your timely topics and the presentations. I have 2 questions. One, François, why we need to have GCM while Canada has signed the 1951 Convention on the Status of Refugees? 2, Mirja, what is the negative role of Section 1 of the Canadian Charter of Rights and Freedoms in ensuring substantive equality for the disadvantaged? So perhaps François could answer the first question and then to Mirja.
So 2 points. 1 point for the question in the chat. The 1951 Convention only applies to refugees. Refugees are close to 70 million in the world today, but migrants are probably just over 300 million. Migrant workers are not necessarily refugees. They may be, but they're usually not. And therefore, the Geneva Convention only covers one part of the migrants. Now, migrants are covered by all the human rights conventions and treaties and statuses. So, and often also by constitutional guarantees. So this is how we need to tackle that. But I'd like to also answer Richard's question about the social discourse. And I'll do that by using an anecdote. We know what the social discourse about migrants is. We know that if you ask people on the streets questions like, are there too many Muslims in the country? They will say, oh, yes, too many Muslims, they're changing our values. And then you ask them, so you want Mohammed, who holds the grocery store at the corner, to go home? And they will say, oh, no, we've known Mohammed for 20 years. His kids are going to the same school as our kids. So no, we want him to stay. It's the others. So very often it's this generalization, the stereotyping, because migrants themselves do not have a voice in our public debates, especially undocumented migrants and temporary migrant workers. And I'd like to come to an anecdote which illustrates the issue quite clearly of why there's an implementation gap. I was on the Committee for Immigration and Citizenship at the Quebec Bar, and we had quite, regular anecdotal evidence of lawyers who would swindle their clients. They would take $2,000 and then do nothing, accompany them to the Immigration and Refugee Board, sit at the back while, playing on their phone or answering emails while the migrant was talking to the people at the IRB. And so we had that, and we told ourselves there's something to be done here. Problem was, there was not one single complaint to the Syndic du Barreau du Québec from migrants, because migrants do not complain against people in power for fear of being returned home, that fear that I'm talking about. And when we went to see the inspection, l'inspection du barreau, they said, oh, we only inspect, the financial records of the lawyers. We don't do that kind of thing. So there was no mechanism. Complaint mechanisms for migrants do not work. And to add insult to injury, we prepared a questionnaire for civil society and board members and lawyers in order to gather evidence for that practice of swindling migrant clients. And when it arrived at the executive committee of the bar, it was disallowed. They said, no, this is not going to go. It could spread rumors about the bar. It's not a good thing. And so we don't have anything. So this is the type of attitude towards migrants. We have complaint mechanisms. Why don't they use them? Well, they don't use them sociologically. So why don't we have labor inspections? But labor inspections don't work for migrants. They don't go to protect migrant workers, and especially not undocumented migrant workers. And so that was the little anecdote to illustrate the lack of how the lack of social capital prevents them from participating in the public debate, making their voice heard, and bring the reality check of their lived lives in order to change policies.
Thank you, François. Mirja, would you like to answer the question? Would you like me to read it again?
No, it's all right. I saw it in the chat. Thank you. So I know there's two presentations coming up about the right to equality. So I don't want to venture too much into my my colleagues' subject matter here. But I already mentioned in the answer I gave to Richard earlier that there's a methodological problem when it comes to handling or making social rights justiciable. So. And I think, the section 1, or the way that the Oakes test works, is a prime example of that. It was, I'm not saying it's a bad test. It's just a test that, applies or takes for granted that we're talking about negative rights, because it takes for granted that there is state action. Whereas, a big part of what I was talking about, these are issues where there's a whole lot of government or state inaction. So it's difficult to apply the Section 1 test to those cases. But again, methodology, those tests are supposed to make rights protection effective. They're supposed to make them, it's operationalization of rights. Well, if they can't operate, then you have to find something to make them operate. So it's, it's really a sort of twisted logic to say, oh, the Oakes test doesn't work for government inaction. So again, we can't include that in our rights. So I think it's in that sense that the Section 1 could be improved, I guess, or the test to make it work. And I'll leave it to my colleagues to speak more about substantive equality.
Thank you. So Maria Rodriguez.
Thank you. Thank you to all the panelists for this very insightful presentations. In my own research, I'm very interested in the right to health specifically, and I've been looking at this divide between the positive and negative, kind of the stand that the Supreme Court has taken on this and how unhelpful it is. And in looking at this, I can help but also think of the jurisdictional divide, how the division of powers also has an impact in how certain rights are operationalized or enforced. So I was wondering, perhaps more specifically for Professor Trilsch, but maybe for all other matters also, how do you see as a negative impact the division of powers between provincial and federal government, and the lack of guidance from the Supreme Court in terms of the obligations that are encompassed in certain rights and how they should be applied across Canada? Because I'm thinking, for example, specifically on access to abortion. You know, there's a case that decriminalized abortion in Canada, but then there's no guidance in how access to this health services should be provided across Canada. And then it's a very piecemeal approach across all provinces, and access is in fact inequitable. So maybe if you could speak a bit about the jurisdictional divide and the problems this poses for socioeconomic rights, but also right to environment or migrants as well.
Thank you.
So maybe I can start, and if my colleagues want to add to that. I think you're absolutely right, Mirja, that the jurisdictional questions do have an impact on the protection, especially of social rights. And I mean, I guess the example that comes to mind is the case of the little Indigenous boy, Jordan River Anderson, who suffered directly from a jurisdictional conflict between the provincial and the federal governments about who should pay for his healthcare services at home, which is why he couldn't go home and he died in hospital. And it's a really sad story, which shows how individuals can be directly impacted in their daily lives by jurisdictional conflict. So when it comes to criticizing government inaction under charter rights, of course, then we can get into those jurisdictional conflicts about, well, whose responsibility is it to provide certain services or to make certain programs to legislate on certain issues. But I think what the Jordan principle also shows us is that rights should come before jurisdictional conflict. And I realize it's difficult for the Supreme Court to judge first and then let the governments figure it out. But on the other hand, I mean, in health, there's already some sort of shared competence. So, it should be possible to figure out those jurisdictional conflicts within charter jurisprudence. I mean, there's ample jurisprudence on those conflicts, and so I don't see why it shouldn't be possible to figure it out in charter jurisprudence. But you're right, that is probably one more hurdle to overcome.
I might I'll just jump in and say, I think in relation to, so environment also is obviously a shared responsibility between the provinces. And actually it's been a problem in the recent Quebec Court of Appeal decision, where they decided that the youth climate case launched here in Quebec, Angers, was not justiciable. One of the things they said was, climate change is such a complicated topic. It will require negotiations between the province and the federal government, and we can't get into that as a court. So I think it's a problem. And I've recently just put together an article where I reviewed all of the climate cases in Canada. And what's interesting is whenever the federal government's authority to act on climate change is challenged, the courts have come up and said, no. The urgency of climate change justifies federal powers here. And yeah, of course, there's some, impact on provincial autonomy, but it's minimal, and here's all these things. Now, whenever their inaction on climate issues have been challenged, suddenly the courts are not talking about urgency anymore. They're talking about, oh, it's too complicated for us to deal with as a court, and too many powers and actors involved. So I do think that that's a problem. I hate to invoke the Tobey Maguire Spider-Man movie, but I do think basically, if with great powers comes great responsibility, and I think that's a problem, that we keep recognizing those powers, but then it's perfectly fine if you don't use them. Is strange to me, or unfortunate anyway.
Maybe a story which is uplifting about this divide in powers, about the access to healthcare for migrant children. The story is actually quite nice. The issue was triggered by the fact that children born in Quebec of undocumented parents, therefore Canadian citizens, who have always resided in Quebec, were considered non-resident by the RAMQ because that was their parent status, and therefore the children had the status of the parents and did not have access to public health care in Quebec. And so there was a big campaign by stakeholders, etc., to make sure that these kids would have access to health care. They are Canadian citizens residing for their whole life in Quebec. Why aren't they considered as resident for the purpose of Quebec healthcare? And so a bill was presented last early in the fall or in August, and that targeted this. And then came the parliamentary hearings at the Assemblée nationale du Québec, and plenty of people came, and including, I was representing the International Bureau for Children's Rights, and most of us said, it's not only an issue of Canadian children of undocumented parents, it's an issue of all children having the right to health care. And the traditional response of the Quebec government had always been, but these are migrants, therefore it's the federal jurisdiction, and we shouldn't pay for them, just like we don't pay for healthcare for the first 3 months of asylum seekers coming to Quebec, etc., etc. And in this case, is it the pandemic or is it an enlightened minister? Minister Dubé actually listened. And when we had the revised version of the bill, it included all children in Quebec who reside in Quebec and intend to stay. So it excludes children of tourists, it excludes, etc. But all children in Quebec have access to healthcare. Not their mothers and fathers, not pregnant women yet. I mean, there are limitations to that, but at least one minister, maybe because of the pandemic experience and the fact that migrant workers were considered essential in the healthcare system and in agriculture, there are many factors that may have intervened, but one minister decided to simply forget about jurisdictional issues and say, okay, all the kids will have access to healthcare, period. Just as the Quebec government had adopted the rule that all children can go to school in Quebec, period, 4 or 5 years ago. Thank you.
Thank you. So we have just under 13 minutes, and I have at least 3 people with questions. So we first go to Molly Hamilton, and she'll ask a question.
Thank you so much. Good morning, everyone, and thank you for your presentations. My question is directed to Professor Crépeau about migrants, and specifically in Canada. I think the situation, we tend to get away with our migrant policies because at least we're not as bad as our neighbors south of the border in a lot of ways. But I think that ignores a lot of the abuse that goes on in Canada, and recognizing that the Charter and legal avenues aren't accessible, but also recognizing that the Charter is supposed to be there to protect in a lot of ways the rights of migrants. Like, how do we I'm trying to think of how to properly phrase this, but how do we minimize that gap of, the charter is supposed to be there to protect migrants, or, it applies to, some sections apply to people that aren't Canadians, but then the migrants don't have that access in a lot of ways because of fear of speaking out. So what do we do? Where do we go from here? I know it's a big question, but if you have any thoughts, I would appreciate it. Thank you.
If I had an answer to your question, it'd be very rich. The answer is we must work at it. We all must work at it, and there's lots of work to be done. What is essential to me is for the migrants' voice to be heard by the public. That can be done through the courts. So if we could find ways to increase public funding, private funding for strategic litigation for migrants in order to enhance their access to justice so that they wouldn't fear complaining, wouldn't fear protesting, that would be an avenue for having their voice heard. Unionization. I mean, the only thing that worked for industrial workers in the 20th century was unionization, getting together and fighting off the powers that be. Unions have been reluctant to protect migrants because of all sorts of things, but they often saw migrants as unfair competition for their members instead of seeing migrants as their future members. That is changing. It's changing in agriculture for obvious reasons, but it has to change also in construction, in care, etc. So I think unions need to embrace a category of workers who are in the same situation as the 19th century industrial workers for whom they were created. And it's not yet there. It needs to change. The media representation of migrants and the media work with migrants needs to change as well. It has started. 15 years ago, on migration issues, most media outlets would simply reproduce what the minister had said in the last speech, and that was it. Since, for the past 10 years, we've seen now journalists in many good outlets, I'm not talking about the yellow press for sure, but we've seen many journalists actually interviewing migrants, migrant families, and we've seen that, for example, in the past few weeks regarding Ukrainians, having Ukrainians tell their story about, how their houses were bombed, etc. So this has changed. It needs to be even, further enhanced. So migrant associations need to find better funding and need to find ways of telling who their members are, etc., etc. So there's a lot of work for a lot of people. I think that social workers, lawyers have work to do on that. It will be a slow process, but I think that is the only thing that will push politicians to consider that there is an electoral threat if they do not take care of this issue. And that is the thing that will change policy. Thank you.
Thank you. So I have a question from Slava Balan, and I'd be grateful if you could, any of you or all of you could answer in a few minutes, because we have another question after that. So Slava Balan, who is a PhD candidate at University of Ottawa and who graduated from McGill Faculty of Law with a LLM. He writes, thank you for the great presentations. My question is, if the Canadian human rights system have so many gaps vis-a-vis international human rights standards, economic and social rights, rights of migrants, could it be then said that Canadian understanding of human rights is not compliant with the universalism of human rights? And he's clarifying, saying that universalism of human rights is equal to universal understanding of human rights and universal application of coverage of everyone and everywhere by these universally understood human rights. So he's basically asking whether we do not subscribe to the universal human rights paradigm if we say there are so many existing gaps in realizing these rights. So over to one of the three panelists.
I can start because I think I basically already said that in my presentation, that I think, yeah, you know, there is no equal treatment of civil and political rights on the one hand and economic and social rights on the other hand. So I think that the official position in Canada is that, you know, economic and social rights are nevertheless protected under you know, ordinary legislation, and you know, there are plenty of social benefits, and you know, there's a public healthcare system and all of that. But yeah, I mean, like I said, the Committee for Social and Economic Rights regularly says that it's a problem, that, you know, one set of rights is just civil and the other one is not. So yeah, I guess I would answer yes to that. And if I can take another 30 seconds just to reply to something that François was saying earlier, the case of migrant children who are Canadian citizens and who became eligible for the RAMQ last year. Having worked on that case myself with the UQAM's International Human Rights Clinic and Médecins du Monde. And I don't want to spoil François' optimism in that case, but you know, what we initially tried was to frame it as a charter case, to say, you know, can we use the charter to force the Quebec government to give those children of parents who are not themselves eligible for the RAMQ access to the to health insurance. And it became obvious pretty fast that that is a really difficult task, even under Section 15 of the Charter, because you know, poverty, social conditions is not considered a motive of discrimination. So, and there were cases before the Quebec courts to try to challenge the La Loi sur la RAMQ. And yeah, it was just really difficult to. So I'm happy that the legislation was adopted in that sense. But I would have been even happier if that could have been, you know, achieved through a charter challenge. Thank you.
Maybe I can add to that on migrants issues, but in many other issues, I suppose. Canada's reputation is much higher than Canada's, you know, implementation of human rights. Because we have a more open immigration policy for the people we pick and choose around the world, we have this reputation of being open to immigration. In fact, it's true, we have a more open immigration policy. We welcome more people per capita than many other countries, but we have the same restrictions on rights. And the idea that migrants have rights is still not embedded in Canadian policy and practice. We can see that from many directions. One of them, just to give an example, one human rights convention, which is often forgotten, is the 1990 International Convention on the Rights of All Migrant Workers and Members of Their Families. This convention was adopted in 1990, negotiated in the 80s, has been ratified as of today by 57 states only, all of them from the Global South. And when I asked Canadian officials about, you know, Canada's ratifying this, the answer was, oh, no, this is a group of 77 international convention. We're not part of that. We don't want to be part of that. And that convention doesn't do anything more than specify for migrants what the covenants are saying, just like CEDAW specifies for women what the covenants are saying, or the Convention on the Rights of the Child is specifying, making more precise for children what the covenants are saying. The one of the big hurdles for all host countries, especially global north countries, but not only them, was, for example, that Section 3 of that convention recognizes that undocumented migrants have rights. And for Canadian officials, that's an absolute no-no. They will not, sign anything where undocumented migrants could have rights, even though they do have them. They do have them in virtue of the Charter, the covenants, the Universal Declaration, and all other conventions. But saying it was impossible, and it's still impossible. So yes, reputation is well above implementation in Canada.
So there is 1 minute, and I want to check. I have one question which is in the queue for a long time, and I'd like to just end there. It's coming from Noor Rashid. It is clear that the pandemic has imposed additional barriers with respect to mobility. Has there been any effort to look at the disproportionate impact of the pandemic, which it continues to have on low-wage migrants? In this regard, are existing mechanisms to protect migrant rights adequate, or more is needed? So obviously more is needed, but last sort of words on this question, François, from you.
A few words. I mean, in countries like Canada and Europe, the transition from pre-pandemic to pandemic to post-pandemic certainly has had an impact on migrant, and especially low-wage migrants. But where it has been felt most was in countries like the Gulf countries, where people have been fired, returned home without pay, without being paid the 6 months of pay that they were owed, et cetera, et cetera. So everywhere, migrants' rights were a casualty of the pandemic. We certainly, again, we need migrants to be empowered, just as the Global Compact says, to fight for their rights, like all other groups. No minoritized group in any country has been given their rights on a silver platter. You always had to fight for them, and migrants are disempowered to fight for them. So we need to empower them. So is it adequate? The norms are adequate. The mechanisms to access them are not.
So thank you very much to François, Sébastien, and Mirja for really an illuminating sort of session. We learned a lot and look forward to the second panel, and hopefully it'll connect themes and issues to what has been said in this panel.